Okay, good evening, everyone. Thank you so much for your patience. Thank you, Meg, for getting our audiovisual connected. We will now call to order the May 14th, 2024 Milford Zoning Board of Appeals meeting. Please stand for the Pledge of Allegiance.
Okay, I'm going to call a roll. Mr. Montano.
Here.
Mr. Soda.
Here.
Mr. Dubois.
Here.
Mr. Enick.
Here.
Mr. King.
Here.
And Mr. Hirsch may be joining us later, and Chairman Ferrante.
Here. Okay, and voting tonight in place of Mr. Wolf will be Mr. Dubois. And we will begin with item number 1. Mr. Montano.
Madam Chair, 240 Edgemont Road, MVP 18/9/1, A, R10, Kevin Crusaden, Esquire, for Barank and Sarif Sulik, owners, vary section 3.1.4.1, front yard setback to 11.1, where 14 feet is required for enclosed front entry. Thank you.
Good evening, Madam Chair, members of the board and staff. For the record, my name is Kevin Crusaden. My office is at 3 Lafayette Street, Crusaden and Moore here in Milford. I have just a handout to pass out to the board. With me tonight is Vulcan Korkmaz, the applicant and the occupier of the premises. He's related to the owners. He's also here with his family this evening. All of the notices were properly mailed and the signs were properly posted as far as the notice requirements go. So the reason we're here tonight, the variance application is a result of an enforcement action that had started some time ago. The court case goes back to at least 2021. Stephen Harris brought a zoning enforcement action alleging multiple violations of setback requirements. I got involved well after the fact, only about maybe 6 to 9 months ago. The applicant recently filed special defenses and counterclaim to that enforcement action. We've had a lot of discussions with Stephen, with DPLU, with the city attorney's office. And the applicant has taken some actions to remediate some of the claimed violations. And after all of those discussions and time, the parties have determined that there's one, one variance required that would resolve the underlying enforcement action, and that is for the enclosed front entryway on Edgemont. There were previous front yard setback variances granted in 1988 for the property in order for the house to be constructed in the first place. I've attached a copy of that variance as Exhibit A to the handout. That house was approved and built with a front walkway that extended into the setback as of right, since it was not enclosed and not part of the principal structure. And I've included a copy of that map, but that's also on file. Since that time, a stoop was constructed at the front door and the walkway relocated. To my understanding, that was as of right. There wasn't any setback violations at that point in time. And then a few years ago, the applicant, on a good faith belief that he could enclose the front stoop area, did enclose the front stoop area, and That enclosure is now the subject of this variance request because once you enclose something and open it up to the principal structure, it becomes part of the principal structure. So the original front yard setback variance for Edgemont Road, which was 14 feet, he's now extended the principal structure into that by 2.9 feet. The reason for, he's here tonight if you have any questions for him, but the reasons that he and I have discussed several times since we first talked were that's a location that offers protection from the rain, snow, and ice as a transition area to removing shoes, etc. So just a little bit of background about the lot itself. I mean, you can see it's not even really a triangle. It doesn't have three angles. It's got like around it, it's got an arc, it's got two angles. It's not a rectangle, it's not a square. It's comprised of three old 1914 map lots or portions of those lots. It consists of 6,100 square feet, where 10,000 square feet required. It wasn't even a legal size lot when the zoning regulations came into play 15 years later in 1929. It's 50 feet wide on Spring Street where 70 feet is required, and then it's 146 on Edgemont, but as you can see it gets more narrow and narrow as it goes from, I think, east to west. I have the standards for granting a variance. Single-family house, I mean, the use is allowed in the zone. It's not going to violate the comprehensive plan or the zoning, of Milford. A lot of single-family houses have enclosed front steps, stoops, or closed front entryways, I guess I should say, for people to, enter into the house and take off their shoes or coats or whatever they need to do. The legal hardships are clear with the shape of the lot, the size of the lot, the lack of the proper width, at least on Spring Street. The lot's undersized by 39% or 3,898 square feet. And those are standards that if the board, those would support a legal hardship. And I did include like I said, the previous variance and some other maps, some pictures of the interior, what it's being used for, are attached as Exhibits C and C1. And I included the old original map. And pending your questions, we'd ask that you approve this variance tonight. Thank you.
Mr. Crusaden, when was this stoop enclosed?
In 2020.
2020. And was anything else done at that time that changed the house from the 1989 build?
There was some other, there was some decks and things that were part of Stephen's original notice of violation and enforcement action, but I don't know if they didn't change the house or increase the setback as far as the house goes.
But that's all been cleared up with all of your conversations with various departments because we're only here tonight for the enclosure?
Correct.
Okay.
And some actions that my client took to move a shed and relocate some things, correct. Yeah.
Okay, good. Good. Okay. Any other questions for Mr. Crusaden? Yep.
That was my question, Attorney Crusaden. The shed's being relocated to within the 4 feet of the property?
Correct, yeah.
And how about the pool? Is the pool in violation?
No.
Because that's 4.8 feet. How far does the pool have to be from the property line?
I'll defer to Stephen, but we've had a lot of discussions back and forth about that. I think it's an accessory structure, right, Stephen? Is it 4 feet from the property line?
Yes, that's right. The only item up for discussion is the enclosed entryway.
Attorney Crusaden, how are you?
Good, thanks. How are you?
Good. You mentioned that there were other properties in the neighborhood that had the similar enclosed stoop. Do you have any addresses?
No, I don't. When I speak of those things, I don't speak about neighborhoods. I speak about zones because that's what the case law says. So my point of that conversation, the point of that was that there's other properties in the single-family houses in the R10 zone that have front entryways. I don't have specific addresses.
All right, thank you. Is there anyone else speaking in favor of this application? Is there anyone opposed to this application? Does the board have any more questions? Okay, then this hearing is closed.
I move to approve as presented the petition of Kevin Hussein Esquire for Barak and Sarif Salik, owners to vary section 3.1.4.1 front yard setback to 11.1 feet where 14 feet required for enclosed front entry.
Second.
Great. Okay, discussion on this item. It sounds like there's been a lot of conversation with the various city departments to remedy everything that's been done at this house. This is the last remaining issue. It's on the footprint of the stoop that was existing. It's the only issue before us. I don't see a problem.
I don't see a problem at all.
The shape of the lot seems to be a hardship. I don't see a problem either.
Yes, significantly undersized for the zone as well as being a corner lot at the same time. Okay, well then we'll move it to a vote. Mr. King,
With the motion.
Mr. Soto,
With the motion.
Mr. Montano,
With the motion.
Mr. Dubois.
With the motion.
I'm with the motion. It passes. Thank you. Okay, and my apologies for not stating this earlier, but the next item on our agenda, 624, 626 Gulf Street, has been postponed to next month. So if you're here for that item, you can come back in June. Sorry, I forgot to mention it earlier. And on to our next item, Mr. Montano.
Madam Chair, 1201 Boston Post Road, MVP 89/81, 12/4088, SCD, Anastasia Sloan, agent for Aaron Cullen, owner, variance sections 5.18, parentheses 1, to allow event to exceed 14 days to operate quote-unquote fun box, a children's amusement area in the mall parking lot from 5/27/24 through 9/29/24. In the mall, we're talking about the Connecticut Post Mall?
That's correct.
Okay, thank you.
Thank you. Please begin.
All right. Good evening, ladies and gentlemen. Thank you very much for your time to hear us out here. My name is Dan Sloan, along with my wife, Erin, and our business partners. We are Funbox. Funbox is the world's biggest bounce house. It's an inflatable bounce house, 25,000 square feet, that we are erecting in the Connecticut Post Mall parking lot. Our being here tonight is to request an extension for our temporary use permit to September 29th. And we had the pleasure last year to be at the Connecticut Post Mall operating throughout the summer, and we had a great time providing outdoor family fun, fresh air activities for kids. And we're requesting to do the same thing again this year. We just need to extend that temporary use permit through September 29th. And that is our request from you.
And what were the dates last year?
Pretty much the exact same dates. We operated from June through the first week of September. Our last day of operation is Labor Day, that Monday in September.
And that was successful enough to extend for another month?
Well, so we run that long, and then we have about a 10-day period where we break down, so we're just trying to make sure that we're only going to operate through the 2nd of September. We just need that extra time to break everything down and get the parking lot cleaned up.
4 weeks to break down?
No, we'll only need about 10 days total.
So can we go through September 12th, not the 29th?
Absolutely.
Well, that's kind of tight, especially if you have a lot of rain or something, so. I mean, I really don't have a problem with the 29th. I mean, he's going to clean up and get his stuff out of there.
Will you be extending beyond the 2nd if there are rainy days?
No, there's no plan for that.
Oh, rainy days for cleanup?
I mean, rainy days for cleanup.
Cleanup,
You can't,
okay, sure.
you can't roll those things up when they're wet. You have to let them dry out.
Yes, correct. Because we'll be putting it away for the season, and then it'll sit there wet in the trailer also. So yes, thank you for understanding that.
Any other questions for the applicant?
Am I correct in saying, good evening, how are you?
Hi.
Am I correct in saying you've already been approved for the 2 weeks
Yes,
and you were looking for an extension?
correct.
And you did this last year, got 2 weeks, and then also had to get approved for an extension as well?
Correct.
And you had got that extension? And you got that extension last year?
We did get the extension, yes. We operated through that first week of September.
Okay.
To be clear, Mr. King, the dates requested are May 27th through September 29th. So it's quite in excess of 2 weeks.
Excuse me, I was making sure that he was actually approved for the 2 weeks already, and that he was only here for the extension. That's why I was just wanted to double check.
Mr. Harris?
Madam Chair, the applicant can operate for 14 days by right, and they've applied for zoning and building permits for that, and were granted a zoning permit, probably building permit too.
Yes.
So they can operate for 14 days by right. So they're here to ask for variance to operate into September, which requires the variance.
Okay.
Yeah, they came before us last year for the same thing.
Yeah, I remember. Okay. Any other questions? No? Okay. Is there anyone else speaking in favor of this application?
Yes, we have Ken here from Connecticut Post Mall.
Great.
Good evening. Ken Sturba, General Manager, Connecticut Post Mall. Yeah, we brought Funbox back this year. They were so successful last year. They're a model tenant. We love working with them. And again, it was our number one social media post of the year anytime we put anything with Funbox. And we had nothing but positive feedback from the community. And we want to extend the time this year and utilize that big back parking lot that we have.
Wonderful. Thank you. All right. Is there anyone else speaking in favor of this application? Is there anyone opposed to this application? Do the commissioners have any more questions? No? Okay. This hearing is closed.
Thank you.
I move to approve as presented the petition of Anastasia Sloan, agent for Aaron Cullen, owner, to vary section 5.18, 1, to allow event to exceed 14 days to operate Funbox, a children's amusement area in the mall parking lot from 5/27/24 through 9/29/24.
Second.
Okay. Thoughts?
Oh, I have no problem with this. I mean, it's a good thing for the city.
You did it last year. The landlord seems to like it. I've seen it. I drive by there last year. It seemed like it was well attended, so I don't see a problem with it either.
Thank you.
I have a question about security. You're gonna...
The hearing is
Oh,
closed.
thank you. Okay, I'm sorry.
I'm happy to answer. Okay.
Okay. We'll move it to a vote then. Mr. King,
With the motion?
Mr. Soda,
With the motion.
Mr. Montano,
With the motion.
Mr. Dubois.
With the motion.
I'm with the motion. Thank you.
Thank you.
Next item, Mr. Montano.
Madam Chair, 3 Lawrence Court, MVP 28/579/2, R5, Thomas Lynch, Esquire, for Teresa Kovaleski and Scott Digris, owners, bearing section 3.1.4.1 east side yard setback to 1.3 feet where 5 feet required. West side yard setback to 7.3 where 10 feet required for an addition.
Good evening, Madam Chair, members of the board. Just for the record, my name is Thomas Lynch. I'm an attorney with the law firm Lynch, Trimbicki, and Boynton, and my office is located here in Milford at 63 Cherry Street. And I have the pleasure of appearing before you tonight on behalf of my clients, Teresa Kovaleski and Scott Digris. Teresa and Scott are the owners of the property at 3 Lawrence Court. It's located in the Bayview section of Milford in the R5 zone. And the application before you tonight is to vary section 3141 for both of the side yards to basically extend the house out and build a 29 by 26 addition to the house. Just by way of a little bit of background, my clients have owned the house since 2001. Between 2011 and 2012, the house was virtually demolished by the combination of storms Sandy and Irene. My clients rebuilt the house utilizing a FEMA grant for the foundation and the raising of the house that took place a number of years ago. And right now they have a 3-bedroom 1,800 square foot house with 2 levels of living space. We did send in some pictures in addition to the site plan, just to show, in the background, the prior configuration on the property, the house, you can see now after it was raised, the current situation with the stairs that are in the front, but we also had another picture that showed prior to the raising of the house, there was a detached garage that was in the front yard. You can see that has been removed now. So just by way of background and history on this property, there was a detached garage, there was a structure in the front yard, and that was removed. So this addition is not going to encroach whatsoever on the front yard setback. It's going to come out from the front of the house. It's going to keep the existing setbacks as are there now with the existing house. It's just going to bring the structure out 29 by 26 feet. And the intent is to have 2 levels of additional space with a study and a bedroom on the second floor, and most importantly, an elevator. Both of my clients have physical disabilities that they're dealing with right now, and as well, Teresa's mother, the intent is to have her move into the house so that, as you can see on the floor plans, and Stephen's showing you the elevations now, but the floor plans show that there is an elevator that will service the house. It's going to be built within the confines of the addition and go from the garage level up to the second living level. The stairs that do protrude from the existing structure are going to be removed. That is the area where the addition would go, and then there's going to be an extended garage, so there'll be a tandem garage situation on the first floor. I believe this is a very reasonable request. Obviously, it's a very narrow lot. It's a 4,200 non-conforming lot in the R5 zone. I will let you know that I spoke to Hugh Keefe. Attorney Keefe is the owner of the property next door, number 1 Lawrence Avenue. He called me this afternoon from his office in New Haven to let me know that he's been good friends with Scott and Teresa for the 24 years that they've been living there, and he has no objection whatsoever to this request that we're making tonight. So that's the extent of our presentation. Happy to answer any questions if you have them, and would hope that you would act favorably on this. Thank you.
Mr. Lynch, the stairs that are currently projecting out, You said they're going to be removed and rebuilt?
They are, Sarah. There's going to be a side entrance now. As
Sure.
shown. That's the west elevation of the house. So the stairs, the entry into the house now will be removed and it'll be moved onto the side.
So how far out do the stairs currently go, and will this addition exceed that?
I think that's shown on the survey, Stephen, if we can get it on the screen.
No, that was my question too, Attorney Lynch. The stairs are not, the front stairs aren't shown on the survey, just the back stairs.
Steve, do we have the...
No, Bill, it is here.
This is the survey. This is
So if you can see, Sarah, on the right side of the shaded area, the steps come almost right to the line of the addition.
I'm sorry, what was that?
See, Stephen has the cursor on the existing stairs.
Okay.
So they come basically right to the same length as the addition. Yep.
All right.
They're going to be moved to the side of the
They're going to be
addition,
moved to the side, yes.
but they're not shown on the survey. The old ones are shown, but not the new ones.
They're shown on the elevations, they're not shown on the survey.
Correct, correct.
Right.
So how far are those going to be from the property line? Are you including those in the variance request, or? In the back corner, it's 1.9 feet.
It's a projection?
The projection will be inside the setback. These,
Because right now you have
this new stair,
I
Yeah,
see, yeah, no, I
7.6. You have
got
7.6 feet there now, and the stairs are probably going to be at least 4 foot wide.
this new setback, right, this is the new addition.
Right.
These new stairs, and I missed this when I looked at it.
It's
They're not
gonna need a
shown- They're not
projection.
shown on the survey.
Okay.
So these most likely would require an additional variance because the house is set back 7.6 feet from the lot line, where 10 is required.
All right, so why don't we do this? Keep the public hearing open. If I can adjourn it to next month, and I'll have the surveyor revise it and actually revise the application. I mean, the main point is we're removing the front stairs and we're putting them on the side. And, you know, obviously that's not on the application, so. Is that fair enough?
Yes.
Yep.
Okay, so we'll keep the hearing open and continue next month.
Okay, thanks.
All right. Thank you, Mr. Lynch. Okay. Next item.
Madam Chair.
No, Gulf Street has been postponed to next month. Gulf Street was postponed to next month. Mr. Lynch? We have a request for next month's materials.
Could you just have them do an outline of where the existing garage used to be? Because
The detached garage?
the detached
The
garage.
detached that was
Yeah.
removed, it was removed a number of years ago.
Oh, okay, okay.
So in
Actually,
other words, when they raised the house and they put the stairs in
They
the
took it
front,
down there.
that's the area where the
Okay.
garage was.
I'm actually curious about that too, though. I'm wondering if the addition is
We
going
can
to...
show that. I can have him show
Yeah.
where the garage was before.
Probably the tax records still have it.
Yeah,
So,
great. Thank you. Okay, next item, Mr. Montano.
Madam Chair, 4 William Court, 63/928/11B, R30, Thomas Lynch Esquire, for Richard Reza, owner, variance section 3.1.4.1, east side yard setback to 10 feet, where 20 feet required to construct new single-family residence.
thank you. Again, Madam Chair, the members of the board, Thomas Lynch. On this application, I'm here tonight with my client, Rick Rizza. I've known Rick my whole life. Rick's family owned the Riverside Pharmacy, which was located across the street at 111 River Street for many, many years. My father had his law office in an office above the Riverside Pharmacy, so we go way back. And Rick has lived in Milford on and off most of his life. He spent a period of time in Vermont running an inn in Vermont, and he's now decided to come back to Milford and build a new house on Willem Court. So the application before you tonight is to vary section 3141 for the east side yard to 10 feet where 20 feet is required in zone R30 for the construction of the new house on Willem Court. Now, just by way of background, I represented the Andrew Pekarsky Trust back in 2020 before the Planning and Zoning Board. The Planning and Zoning Board granted his application for a 14-lot subdivision constructed and developed on this property. It's turned into one of the nicest streets of Milford. The houses that are being built there, they're all between 3,000, 3,500, 4,000 square feet. They carry a price of $1 million at plus, and it's turned into just a real nice neighborhood. And Rick's house is the second one in. It's going to be constructed on lot 13 in the subdivision. And when we appeared, prior to appearing before the Planning and Zoning Board in 2020, we had to appear before the Inland Wetlands Commission because there is a stream that runs through the middle of this property when it was subdivided. The Inland Wetlands Commission approved the application to build homes within 150 feet, their upland, their review area, but there was a requirement that on this lot and the lot across the street where the stream passes under the road, that there be a conservation easement. So I drafted a conservation easement, worked with the city attorney in terms of the language on that. That was recorded on the land records prior to the subdivision map itself being recorded. So to make a long story short, on the western end of lot number 13, some 13,000 square feet can't be built on. It's part of the conservation easement area. There's also a fence that was required by the Inland Wetlands Agency to be constructed along the border of that easement area, along with signage saying that no one can go in there and remove shrubbery, cut down trees, do anything to disturb the natural nature, the natural condition of that particular area. So Rick's house, as I said, Rick's lot is the lot that has the conservation easement on it. So in terms of laying out his house, he appeared before the Wetlands Agency last month seeking to build within the easement area. And to be honest with you, they denied the application, and rightfully so. I mean, if that easement was recorded on the land records, it was recorded on the land records for a purpose. The purpose was not to have any building within that portion of his lot. And Sarah and Bill probably will remember a similar situation that we had on Tanglewood Circle about 5 or 6 years ago, where there was wetlands on the rear of 2 lots on Tanglewood, and the neighbors were upset because
I'm back on.
Yes, me too.
Okay, so we're back.
I am too.
Where did Stephen go?
All right. All right, is the machine picking me up? Yep. Meg, does this pick up now? Yeah?
Okay, everyone set? All right, we'll call the meeting back to order. Thank you.
right,
Mr.
thank you.
Lynch, please continue.
I'm trying to remember where I left off.
Tanglewood.
Right. So, oh yes. So Sarah and Bill remember Tanglewood Circle. It was the same situation. There was wetlands in the back of the property. We've applied for a front yard setback variance to move the houses forward, and you granted those variances. I hate to say it, we stand before you all the time tap dancing around the issue of hardship and legal hardship. Not on this one. This is a true legal hardship. This is like something out of a land use law school textbook. All right, when you have a condition on the property itself, such as in conservation easement, that precludes you from using that area of your land, and you need to build and you move the house away, you seek a variance so you can move it 10 feet further to the other side, that is a classic legal hardship, okay? And the house that Rick and his wife want to build, it's a ranch-style house, so it's got a longer footprint to it. They're both getting up there in their years, and the intent is to have a one-story house. The other houses, other than Anthony Fino's house at the end of the cul-de-sac, the other houses on Willem are all colonials. Rick's house and the Patchins, who are building a house next door as well, are ranch-style houses, so that to have a reasonably sized house in conformity with the neighborhood, the same type of size and square footage as the rest of the neighborhood, that's what brought us to you tonight with this application. And I will note that in the denial from the Inland Wetlands Agency, they specifically recommended, well, we're not giving you permission to build within this easement, but on the other hand, we encourage you to go to the Zoning Board of Appeals and apply for a variance. So it was actually in the denial that they sent. So that's it. Again, happy to entertain any questions, but this is one of those situations where something germane to the land itself creates a hardship, and it's recognized by courts as a legal hardship. Thank you.
Mr. Lynch, the square footage of this lot is 30,000, but what percentage of that is conservation easement and what percentage of that is buildable land?
13 over 30 is the easement, so that's about 40%. 40% of the lot is encumbered by the conservation easement.
Okay. And how far off of the easement do you need to build? Because this, I'm showing 7.6 feet off the easement. Are you allowed to go right up to that?
Yes. And I already spoke to Mary, here's another point. I spoke to Mary Rose Palumbo, the Inland Wetlands officer. She reviewed these plans, and she couldn't guarantee me, but she felt that the agency would be satisfied with. We do have to go back to the Inland Wetlands Agency because the house is within the 150-foot review, so it would require their review. But she said if this plan would work.
Okay. However, you're asking for 10 feet into the setback, but you've got 7.6 on that side. Is there a reason you can't move the house?
Yeah, they didn't want it right on the fence. In other words, right on that line is a split rail fence. I don't know if you drove out there.
Oh, demarking the easement?
Yes.
Oh,
yeah,
I see.
Yeah,
Okay.
they said obviously we don't want the house on the fence, so that's why there's that
Okay.
difference.
Okay. Mr. Soto?
So let me understand this right. That whole 13,000 square feet is his land.
It's his land, but he can't
Okay.
build on it. Yeah.
Gotcha.
Yeah.
So it's not like deeded open space, it's his land,
It's his land.
but it's got a conservation easement on it.
Correct.
Okay. All right, so I see your point now.
Yeah. Yeah, I don't know. I used to be pretty good in math. 13 over 30, that's, I think, roughly 40%.
0.46.
All right.
43.
Thank you, Andy.
Any other questions? Okay. Is there anyone else speaking in favor of this application?
Oh, Bob? This is Robert Patchen, who owns the lot next door, lot number 14, the one lot that would be most affected by this application.
I have no objection to this. They're very, very close friends of ours, and I gave them the permission if they wanted to come over 10 feet. It will not affect us. So I'm all for it.
Okay.
I
And
have-
you own lot 14 here?
I have 30 feet more than anybody else on the side yard. So giving them 10, I'm still going to have 20 like everybody else. So I have no objection to it.
But she asked you, are you the owner of lot 14? Just say.
Oh, yes.
Yes.
I'm sorry.
Okay, great. Okay, thanks.
Okay.
Thank you. Is there anyone else speaking in favor of this application? Is there anyone opposed to the application? No. Commissioners have any more questions? No. Okay, this hearing is closed.
I move to approve as presented the petition of Thomas Lynch Esquire for Richard Rizza, owner, to vary section 3.1.4.1, east side yard setback to 10 feet where 20 feet required to construct new single-family residence.
Second.
Thoughts?
Well, if anything really is a true hardship, it's that conservation easement. It is his land, and he's not allowed to build on it, so I have no problem with this.
I would agree that 40+% is quite significant. Any other thoughts? Okay. Then we'll vote. Mr. King,
With the motion?
Mr. Soda,
With the motion.
Mr. Montano,
With the motion.
Mr. Dubois,
With the motion.
and I'm with the motion. The motion passes. Okay, Mr. Montano, last item.
Madam Chair, 574 Milford Point Road, MVP 15/51/5A, R12.5, Thomas Lynch, Esquire, for Benjamin and Patricia Kovacs, owners, varying section 4.1.1.4 to allow accessory building of 796 square feet where 919 square feet permitted to construct detached garage.
Yes, again, Madam Chair, for the record, Thomas Lynch on this application. I'm representing.
Mr. Lynch, hold on. I would just like to clarify, because the public agenda, correct, Mr. Harris, said accessory, asking for 952 square feet where 919 square feet permitted. That's what was posted.
Yes, that is a Scrivener's error that was corrected.
Okay,
Yep.
right. So asking for 952 square feet where 796 is permitted.
That's incorrect.
That is the correction, as far as I understand it.
No, it's the reverse.
That was that was a Scrivener's error on my part. I remeasured the area and it came out less than what's on the agenda.
So the application is asking for 952 and 796 is permitted.
Well, I have an email from Stephen on the 23rd,
No, I did send an email
right?
with that number, but that number was an error because I remeasured.
I wasn't made aware of that.
I apologize, that's my fault.
Okay, I'm just saying, the application that we had submitted, I took it off of Stephen's calculations, so if he made an error, I wasn't made aware of it, so that's why I'm saying to you, if I'm looking a little dumbfounded, I'm a little dumbfounded because I'm...
Madam Chair, he can ask for what was advertised.
What's that?
He can ask for what was advertised.
What do you mean?
He can ask for, was it 952?
Asked for 952.
Nine-
That didn't change.
It's been 952 all along. And
He can-
the email that I had says 919 was permitted.
Correct, and I was told that that
919.
is actually
Yeah.
796.
Okay, I'm just saying.
Madam, because it was advertised at 919, he can ask for 919. He's permitted that.
So in other words, I can go,
Because 919 was advertised, now 919 is permitted?
Yes.
Okay.
I made a mistake when I was calculating the area. It was advertised at 919. The applicant is within his rights to ask for 919.
Well, he's asking for
He's
952.
asking for 952. We were saying
That never changed.
the
That never
ask
changed.
didn't change.
919 is the figure, what's that, half the square footage of the house? 50% of the square footage
No,
of the house?
796. Hold on a second, Bill.
Okay. The application,
so in other words, this was wrong in this email? That's your email.
I understand. The applicant is asking for 952 square feet where 919 is permitted. He's allowed, because that was advertised, it was in the legal notice, he can ask for that. I recalculated after the fact, and I came up with a lesser number, but the legal ad wasn't amended. Therefore, this applicant is within his rights to ask what was legally advertised.
Okay.
Stephen,
The
how'd you
ask
come up
is
with the
not
919?
changing.
He is, yes, he is, it was advertised at, he wants 952 where 919 is permitted, because that was advertised. He's allowed to ask for that because the legal notice was not corrected.
No, I understand what you're saying, but the ask hasn't changed. The ask is 952, and that hasn't changed.
Correct, that hasn't
Only
changed.
what is permitted has changed, so you're telling me that what is permitted is now 919.
If there was an error in the calculations, it's probably my error. This is the application that we received. If I vetted it incorrectly, that's my fault. The applicant is within his rights to ask for an accessory building of 952 square feet.
and I don't want to take advantage of that, okay? And I think I have a certain rapport with this board, okay? I don't want to do that. And I just spoke to my clients, and I said, you can have a 919-foot garage. That would mean taking some 30 square feet off of the garage, make it 1 by 28 less. Ben thinks he can do that. So perhaps, why don't we put it over to next month, okay? And then if he can't, and we then re-advertise it at the correct numbers, I'm happy to do that.
Okay.
And then I'll make a presentation. In other words, I don't want to make a presentation to you that's based on a mistake.
Thank you, I appreciate that.
Yeah,
Okay, if that's fine with your clients, then yes, we can keep the hearing open and hold it over to June.
Fair enough?
Okay,
Yeah.
great.
Okay.
Thank you, Mr. Lynch.
So if I can just clarify, Stephen, they can build a garage that has 919 square feet. By us walking out of here tonight, we can get a 919, because you said 919 they could have, right?
It's 50% of the footprint of the house minus the decks. So we can, I can run the numbers one more time for re-advertisement. You can go with what the legal ad said, that's within your rights.
I think
hold it open and...
We're all at a
recheck,
little bit
hold
of a
it open.
stalemate here, understanding the
Yeah,
predicament.
because the way I explained it to my clients is that Stephen was saying it was advertised 919 is permitted, and they're looking for 952. So I take that as saying, okay, if 919 is permitted, then we're out of here. Well, he'll shrink the garage a little bit, and that's why I wanted to get clarification, but it doesn't sound like you're agreeing with me.
Be best if I recalculate the numbers. Sit
Okay.
down with you next week, we can recalculate the numbers.
Okay.
If there's an error, the error is all mine.
No, in one way or the other, this is a smaller garage that was denied 2 years ago. So, I mean, they're coming in here with a certain amount of good faith too. So, all right, let's see if we can work it out, all right? Fair enough?
Okay.
Okay.
Thank you, Mr. Lynch.
Yep, thanks.
Okay. That's it for our agenda items. New business. Any new business? Okay, well, I want to say another welcome to Mr. Einig, who we welcomed last month, but he was not here. So thank you for joining us. Hope you've enjoyed your first meeting, and that's great.
They're usually not quite like this.
Thank you.
Next month, we have 3 postponed hearings. Do we have anything else?
I think I have 3 new applications, maybe 4, so it's going to be a busy meeting.
Okay. Okay, any old business? Staff updates? Welcome back, Stephen.
Rolling out that red carpet.
Okay, we need a motion to approve the minutes from last month.
Make a motion to approve the minutes.
Second.
All in favor? Aye. Okay, and new applications for June, 3 or 4 new ones plus the 3 from tonight. So it'll be a busy June. Okay, and motion to adjourn the meeting.
So moved.
Awesome. All in favor? Aye.
Aye.
Meeting adjourned. Thank you very much.